In our previous lecture, already we have discussed about the competition law as it was prevailing in India as under the very Act Monopolies and Restricted Trade Practices Act of 1969 and as it was amended as Competition Law or Competition Act of 2002 and as it was amended subsequently in 2007 and 2017 and 2022. And now we would like to discuss those important landmark judgments delivered either by the Supreme Court or the Delhi High Court and even by the National Company Law Appellate Tribunal. So, in this regard, we would like to discuss the first important leading case, and that is the Coal India Limited and another versus Competition Commission of India and another, and it was decided by the Supreme Court in 2023 in regarding the very applicability of the Competition Act of 2002 in regards to state-owned monopolies. So the very judgment we would like to discuss. After a 10-year legal battle between the Coal India Limited and the Competition Commission of India on its jurisdiction to examine the conduct of state-owned monopolies, the Supreme Court held that the provisions of the Competition Act 2002 apply to competition and in regards to Coal India Limited and similar public sector undertakings. The Supreme Court decision clarified that Competition Act is applicable to all government companies and statutory monopolies that operate to further common good under the Constitution of India. Given the Supreme Court's decision, the Competition Commission of India's jurisdiction to investigate and take measures against statutory monopolies similar to Coal India Limited in regards to abuse of dominance cases has been confirmed. So, this very particular decision of the Supreme Court was regarding the very abuse of dominance position of the enterprise or industry or the business houses or the particularly those business houses engaged in manufacturing, producing consumer goods and other different kinds of goods. So, in this regard, the very provisions under Section 4 of the Competition Act here, as referred by Supreme Court in this very particular case that is relating to Coal India Limited and another and Competition Commission of India and another in 2023. The Supreme Court held that it would be applicable to all those companies and statutory monopolies. Those are created by the government, and it is even applicable to all those state-owned industries or factories or those manufacturing and producing entities which are statutorily created by the legislative authorities of Government of India or even of state like the Coal India Limited, and it particularly in regards to abuse of dominant or dominant position by such industries or factories or manufacturing units or enterprises. And in our next important leading or landmark judgment, would like to discuss the second one, that is relating to Telephone Act, Tivalosgate Alarm Erection versus Competition Commission of India decided in 2023 by the Delhi High Court, and it was particularly in relating to the Patent Act 1970, and itself is a code as it was declared by the Delhi High Court and prevails over the provisions of the Competition Act. So, the very division bench of the Delhi High Court held that disputes relating to allegations of anti-competitive conduct in the licensing of the patents cannot be examined under the Competition Act and should be examined under the Patent Act of 1970. The decision has effectively barred the jurisdiction of the Competition Commission of India in examining disputes relating to the licensing of patents. Previously, a licensee could approach the Competition Commission of India in regarding to the terms and conditions in licensing agreements which potentially violated the provisions of the Competition Act of 2002. At present, now a licensee will have to approve the control of patents on all issues relating to alleged unreasonable conditions in patent license agreements, including allegations of anti-competitive conduct. So, that is a part of the very provisions of the Competition Act of 2002. So the Competition Commission of India has appealed the High Court, Delhi High Court's decision before the Supreme Court. However, the appeal is yet to be admitted as it was a leading case of 2023. And now we'll go to the third important leading case, and that is relating to Institute of Chartered Accounts of India versus Competition Commission of India in 2023, and the very decision was delivered by the Delhi High Court in regards to the Competition Commission of India does not have the jurisdiction to examine decision of other statutory regulators. So, the Honorable Delhi High Court held that the Competition Commission of India does not have jurisdiction to examine the decisions of other statutory regulators taken by them in exercise of their regulatory functions with no interface with trade or commerce. The Delhi High Court also held that the Competition Act of 2002 does not contemplate the Competition Commission of India acting as an appellate court or a grievance redressal forum against decision of statutory bodies which are taken in exercise of their statutory power. So the Delhi High Court's decision creates an important exception for statutory regulators or bodies from the Competition Commission of India's scrutiny, even if their decisions may create anti-competitive effects. So no appeal has been filed against the decision. As on date of our discussing the very decision. And now we'll discuss the fourth important leading case, and that is Google India Private Limited versus Matrimony.com Limited of 2023 decided by the Madras High Court. And that exactly in relating to civil courts jurisdiction, which is ousted by the Competition Act in abuse of dominance cases, which are falling under Section 4 of the Competition Act of 2002. So, as regarding the very decision delivered by the Madras High Court in this important leading case, Google India Private Limited versus Matrimony.com Limited in 2023, the Madras High Court held that several parties approached the Madras High Court under its civil jurisdiction, seeking a declaration that the terms and conditions imposed by a dominant entry in a commercial agreement were illegal and unenforceable. Rejecting the plaint, the Madras High Court held that Section 61 of the Competition Act expressly bars the jurisdiction of civil courts from entertaining suits based on the cause of action relating to the abuse of a dominant position by an enterprise. The Madras High Court further held that even though civil courts are empowered to go into the question of unconscionable nature of agreement entered between parties of unequal bargaining power under the Indian Contract Act of 1872. The Competition Act, being a special law, will prevail over the Indian Contract Act. This decision is significant as it upheld the jurisdiction of the Competition Commission of India to examine the conduct of dominant enterprises under the Section 4 of the Competition Act. The decision is currently pending in appeal before the division bench of the Madras High Court. And now we'll discuss the fifth important landmark judgment, and that is in regards to Alliance of Digital Indian Foundation versus Competition Commission of India. The leading case of 2023 decided by the Delhi High Court. The mere as it was decided in 2023, the very matter is mere defect or vacancy in the Constitution of the Competition Commission of India does not impede its jurisdiction to adjudicate complaints or any other proceedings pending before it. The Delhi High Court held that the Competition Commission of India could continue its adjudicatory process. So, the very adjudicatory process, even in the absence of a quorum of 3 members, the decision notes that a mere defect or vacancy in the Constitution of the Competition Commission of India would not invalidate the proceedings before it. Prior to pronouncement of the judgment, the Competition Commission of India was unable to issue orders for a period of approximately 6 months due to being incorrect. In February 2023, the Ministry of Corporate Affairs, Government of India allowed the Competition Commission of India to invoke the doctrine of necessity to examine combinations under its merger control mandate to clear the backlog of transaction awaiting approval. However, no such direction was seemingly provided for adjudication of pending enforcement cases. So, when a party approached the Delhi High Court seeking direction to the Competition Commission of India to act as its complaints and provide interim relief, the court examined various provisions of the Competition Act of 2002 and noted a distinction between administrative functions, where the court held that the quorum requirements may apply, and adjudicatory functions, where the court held that there were no strict quorum requirements prescribed under the Competition Act of 2002. So the Delhi High Court also appreciated that the preventing the Competition Commission of India from passing adjudicatory orders would effectively bring its functioning to a standstill, which would go against the very spirit of the Competition Act of 2002. This decision will ensure that the Competition Commission of India continues to adjudicate enforcement cases, including urgent application for interim relief, even if it is inadequate in the future, making sure that adjudication of cases is not halted due to a mere vacancy in the Competition Commission of India's quorum. This decision was appealed before the division bench of Delhi High Court. However, the appeal was subsequently withdrawn. And now we'll go to the sixth most important landmark judgment in relating to competition law in India, and that is Ultratech Cement Limited versus Competition Commission of India in 2003, and also it was decided by the Delhi High Court, where the very exact issue the Competition Commission of India may allow implement of any party with substantial interest and in public interest. So the Delhi High Court ruled that the Competition Commission of India has the power to implement any party to a competition proceeding at any stage provided it satisfies the twofold test of substantial interest and public interest. Under Regulation 25 of the Competition Commission of India, General Regulations, which were issued through Gazette notification in 2009, it further clarified that such an implement does not change the nature of proceedings as proceedings in personam, but merely assists the Competition Commission of India to conduct proceedings in a better and effective manner, enabling it to reach an informed decision. This is one of the first decisions where the Competition Commission allowed the implement of a party after the Director General had concluded its investigation in the matter. The decision also provides much needed clarity regarding the test for implement to matters pending before the Competition Commission of India for third persons who are interested in the outcome of the proceedings. And this decision is currently pending in appeal before a division bench of the Delhi High Court. And now we'll go to the seventh important landmark judgment, and that is Gold LLC and another versus Competition Commission of India, and decided in 2023 by the National Company Law Appellate Tribunal. So, here the very matter was regarding the Competition Commission of India must conduct an effects analysis for proving abuse of dominance under the Competition Act as provided under Section 4 of the Competition Act of 2002. So the National Company Law Appellate Tribunal held that the Competition Commission of India must conduct an effects analysis to prove that an entity has abused its dominant position in violation of the provisions of Section 4 of the Competition Act of 2002. The test to employed while conducting an effects analysis is to show whether the abuse conduct in question is anti-competitive. Notably, the National Company Law Appellate Tribunal also held that the Competition Commission of India cannot impose a behavioral remedy on a dominant enterprise unless there is a specific finding of abuse of dominance in relation to such conduct. So the National Company Law Appellate Tribunal's decision is significant because The very wording of Section 4 of the Competition Act of 2002 does not expressly require the Competition Commission of India to consider the anti-competitive effects of an imposed conduct to arrive at a finding of infringement. However, in contract, the legislature has provided for such a stipulation when the Competition Commission of India examines anti-competitive agreements as provided under Section 3 of the Competition Act of 2002. So the National Company Law Appellate Tribunal's decision marks an important shift in Indian competition law. As jurisprudence were previously the Competition Commission of India has found dominant entities to violate Section 4 of the Competition Act of 2002 irrespective of whether their conduct led to an anti-competitive effect in the market. There have also been instances of the Competition Commission of India imposing positive behavioral remedies on dominant entities without finding a specific finding of abuse in relation to such conduct. Given the National Companies Law Appellate Tribunal's decision, the Competition Commission of India will have to conduct a thorough examination of the anti-competitive effects of a dominant entity's conduct, if any, to support a finding of infringement, and prior to imposing any behavioral remedies on such entity in the ongoing and future cases. The National Company Law Appellate Tribunal's decision is currently pending in appeal before the Apex Court or the Supreme Court. And now we'll go to discuss the eighth important leading case, and that is in relation to the Consumer Unity and Trust Society versus Competition Commission of India in 2023, decided by the National Company Law Appellate Tribunal. So the very issues, the very transaction exempt from merger review cannot be examined under the provisions concerning anti-competitive agreements or abuse of dominance as provided under Section 3 and Section 4 of the Competition Act of 2002. So the National Company Law Appellate Tribunal clarified that the provisions relating to anti-competitive agreements or abuse of dominance cannot be invoked to investigate a transaction that is exempt from notification under the merger control provisions of the Competition Act. The decision provides clarity between the difference in the legal framework for horizontal agreements and mergers under the Competition Act and how they operate in completely in different fields. It further clarifies that while a merger between entities which is exempt from notification to the Competition of Commission of India cannot be examined by the Competition Commission of India ex parte as provided under the provisions of Section 3 and Section 4 of the Competition Act of 2002. The parties' conduct can be scrutinized under these provisions ex post facto if there is some evidence of violation of the Competition Act. This decision will ensure that mergers which are otherwise exempt from notification to the Competition Commission of India are not halted by frivolous complaints and interim relief applications filed before the Competition Commission of India alleging violations of the provisions of Section 3 or 4 of the Competition Act of 2002. And now we'll go to the ninth important leading case that we would like to discuss, and that is the Uttar Pradesh Glass Manufacturers Syndicates versus Competition Commission of India. And it was decided in 2023 by the National Company Law Appellate Tribunal. And the very matter is relating to third parties do not always have a right to submit comments against combinations pending approval before the Competition Commission of India as it is provided under Section 5 and Section 6 of the Competition Act of 2002. So the National Company Law Appellate Tribunal held that third parties are not entitled to submit comments or submission against or in favor of combinations pending approval before the Competition Commission of India unless the Competition Commission of India invites such comments or information. The National Company Law Appellate Tribunal clarified that the public rights of participation arises only when the Competition Commission of India directs the parties to combination to publish the details of the combination to bring the combination to the knowledge of the public and persons affected or likely to be affected. So the National Company Law Appellate Tribunal's decision clarified that combination orders cannot be challenged by third parties on the grounds of violation of principles of natural justice for failing to consider suggestions or objections by the public unless the Competition Commission of India has specifically directed the parties to publish the details of the combinations and short comments from the public as per the provisions of Section 5 and 6 of the Competition Act of 2002. and the very decision of the National Company Law Appellate Tribunal is currently pending in appeal before the Supreme Court. And now we'll discuss the 10th important leading case, and that is relating to Barampur Chini Mills Limited versus Competition Commission of India, and it was decided in 2023 by the National Company Law Appellate Tribunal, and it was held by the National Company Law Appellate Tribunal that the composition of the Competition Commission of India members who hear final arguments in a matter must be part of the decision making and pronouncement of the final judgment. The appellant submitted that the Competition Commission of India's order was patently illegal since it was pronounced by a composition of three Competition Commission of India members, whereas the final arguments were heard by a composition of six Competition Commission of India members. The National Company Law Appellate Tribunal broadly accepted the argument and set aside the Competition Commission of India's order on the grounds that it was pronounced after an inordinate delay of 13 months after the matter was heard, and due to this inordinate delay, some of the members that had final arguments in matter had left office before the final order could be pronounced. The decision is significant considering that several cases during the inception years of the Competition Commission of India were heard by a composition of different members, some of which are still pending in appeal. And now we'll discuss another important leading case, and that is the 11th number of case, and that is the Delicacy Continental Private Limited versus Competition Commission of India 2024, decided by the National Company Law Appellate Tribunal, where exactly as per the decision of the Competition Commission of India in regards to Delicacy Continental Private Limited, which was applied by the Competition Commission of India of the provisions of Section 3, Subsection 1 and Section 3, Subsection 3, Clause C and Section 3, Subsection 3, Clause D of the Competition Act of 2002, which were upheld by the National Company Law Appellate Tribunal, and as regarding the very penalty imposed by the Competition Commission of India as under Section 27, the very penalty imposed for consecutively for 3 years on the Delicacy Continental Private Limited, the very percentage of penalty was imposed by the Competition Commission of India was 5% for consecutively for 3 years, and it was reduced by the National Company Law Appellate Tribunal into 3%. But all the decisions held by the Competition Commission of India in regards to Section 3, subsection 1 and Section 3, subsection 3, clause C, and Section 3, subsection 3, clause D, 3, clause D, were upheld by the National Company Law Appellate Tribunal, and only the penalty as imposed by the Competition Commission of India on Delicacy Continental Private Limited for a consecutive 3 years on the basis of 5% only, it was reduced by the National Company Law Appellate Tribunal into 3%. And now we'll discuss finally the most important leading case, that is relating, which is popularly known as the DLF case. And it was regarding an abuse of dominance. So, as already we have discussed regarding the very provision of abuse of dominance as provided under Section 5 of the Competition Act of 2002. So, the very fact and issue of the case that a consumer association, that is known as the Billari Owners Association of the Project Billari, that DLF had developed, where DLF was accused of abuse of dominance as violation of Section 4 of the Competition Act of 2002. So the Competition Commission of India, in the decision against the DLF, fined DLF rupees 630 crores. So, these are the most landmark judgments on competition law, and almost we have discussed 12 number of important landmark judgments on competition law. As in our research we found more than thousands and thousands important leading case relating to competition law. But out of that we have only selected certain latest important landmark judgments and also some relevant judgments relating to the very provisions in regards to anti-competitive agreements, in regards to merger, acquisition and combinations, and also in regards to those provisions in particularly regarding abuse of dominance position in violation of Section 4. So almost in these very landmark judgments, we have dealt certain important sections such as Section 4, Section 5 and Section 6 of the Competition Act of 2002, and in particularly in regards to the landmark judgments in competition law, almost we have tossed 12 important landmark judgments, and the last judgment relating to DLF case, and it was particularly and regarding an abuse of dominant position, and which is prohibited under Section 4 of the Competition Act of 2002, and where exactly the National Company Law Appellate Tribunal and also the Competition Commission of India fined DLF rupees 630 crores for violation of the provisions of Section 4, which deals with abuse of dominance position. So, hereby we completed competition law and also the landmark judgments relating to competition law.